please the Court. Before lunch we were looking at the Court of Appeal's judgment, and we were looking at that part of it that dealt with grounds 7 to 9 and the challenges to the findings of fact that were made on the appeal. And we were just coming on to look at the conspiracy claim, which is dealt with by the Court of Appeal at paragraph 79 onwards, page 23 behind tab 11 in the supplemental bundle. And the Court of Appeal at 79 said that the conspiracy claim related to the hotel transaction in Georgia, and that the judge found that Mr Azima had conspired with Dr Mossad, Mr Al-Sadek and Mr Adams to induce RAKIA to pay him $1.562 million under a sham referral agreement, on the pretext that the agreement entitled Mr Azima to commission from RAKIA for introducing it to individuals who had agreed to buy the hotel from RAKIA, Georgia. And then at paragraph 80, the Court of Appeal said this: the judge gave a number of reasons for his finding that the referral agreement was a sham, which he set out at 181. That's the paragraph in the judge's judgment we looked at. They included, 1, the implausibility of the alleged agreement to pay the commission plus a share of the sale price. And the court, just pausing there, will recall on Mr Azima's case, under the terms of the original agreement, he stood to receive 5% plus 50% of anything over 50 million. So he would have stood to be paid $10 million on the sale of the hotel at $60 million, which the judge found was implausibly generous for effecting the introduction. 2, the implausibility of a revised agreement, which Mr Azima said he had made. And pausing there, you'll recall on Mr Azima's case, when he had already fully performed his side of the bargain, he then agreed to forego his entitlement to the $10 million he'd been promised, and instead to accept a payment of just $1.5 million. And the judge had said that too was implausible. 3, the mismatch between the referral agreement and the terms of the agreement that had been alleged. And the court will recall that the backdated referral agreement included the wrong names for some of the parties, and included items like an agreement to reimburse Mr Adams for his expenses, which Mr Adams was forced to concede had not originally been agreed and was therefore clearly a sham. And 4, the way in which the referral agreement had come into existence. And the court will recall that the referral agreement was being circulated in draft some 6 months after the transaction and the payments, and it was sent by Mr Adams to Mr Al-Sadek at his private email address, with Mr Adams also requesting if he should send it to Mr Al-Sadek's official RAKIA email address, and without Mr Adams being able satisfactorily to explain why that was so. And in addition, at paragraph 81, the Court of Appeal said, in support of his conclusion, the judge also drew inferences from the fact that, as he found, Dr Mossad received a bribe out of the illicit payments, and from the fact that, as he also found, Mr Al-Sadek was involved in the retrospective drafting of the referral agreement. In paragraph 82, the Court of Appeal also referred to the Adams memorandum, which stated that the purchasers of the hotel were already negotiating the purchase before Mr Azima came on the scene. Now, pausing there, with the exception of the Adams memorandum, all of those reasons which the Court of Appeal found the judge had relied on to find that the referral agreement was a sham were independent reasons that did not turn on the question of whether Mr Azima had in fact introduced buyers to the hotel transaction. And that is one of the reasons, as we'll see in a moment, why the Court of Appeal said that Mr Naebi's evidence, which Mr Azima was seeking to admit as fresh evidence, was immaterial, because the Court of Appeal said it would not have had a material influence on the judgment of the deputy judge, because of all the other facts and matters which the judge had identified and which the Court of Appeal had summarised at paragraphs 80 and 81, and which remained true. And then at paragraph 83 and following, the Court of Appeal turned to address an argument advanced by Mr Azima on the appeal, which need not detain us, that certain matters were not put to Mr Azima and Mr Adams in cross-examination, and the Court of Appeal rejected that argument and that ground for appeal. But at paragraph 110 and following, which we have at page 28 in the bundle, under the heading Fresh Evidence on the Conspiracy Claim, we can see the Court of Appeal turned to consider Mr Azima's other basis for challenging the judge's findings of unlawful conspiracy, namely the evidence from Mr Naebi, who was one of the purchasers, who said that Mr Azima had introduced him and the other purchasers to the hotel transaction. Now, so far as that was concerned, the Court of Appeal started at 110 by referring to the well-known threefold test in Ladd and Marshall with regard to the court's power to receive fresh evidence on an appeal, that the evidence could not have been obtained with reasonable diligence, that it must be shown properly to have an important influence on the result of the case, even if not decisive, and that it must be credible. And essentially, the court then refused to permit Mr Nayebi's evidence because it held that it failed all three requirements of the Ladd and Marshall test. At paragraphs 112 to 114, the Court of Appeal found it was not adequately explained why Mr Azima had not previously sought to adduce evidence from Mr Nayebi or the other purchasers. So the first requirement of Ladd and Marshall was not met. At paragraph 115, the Court of Appeal held it was not clear that Mr Nayebi could be considered to be independent of Mr Azima, and indeed had every reason to be hostile to RAKIA, and Mr Azima himself had previously cast doubt on Mr Nayebi's probity, so the third requirement was not met. But importantly for our purposes, so far as the second requirement is concerned, at paragraph 116, which we have on page 30 of the judgment, the Court of Appeal held that even if Mr Nayebi's evidence was adduced, it would not have had a material influence on the judge's judgment. So the second requirement at Ladd and Marshall would not have been met. More specifically, the court said, third, Mr Nayebi's evidence does not touch upon the judge's main reasons for finding that the unlawful means conspiracy was proved, namely his finding that Dr Massad received a bribe out of the illicit payments. It does not, therefore, go to undermine the judge's central findings of fact. So we say the Court of Appeal has in fact already ruled against Mr Azima on his argument that if he can show that he did introduce the buyers to the hotel transaction, then that materially undermines the deputy judge's findings on the unlawful conspiracy claim, because the Court of Appeal has held that there were a whole number of other reasons, which it had summarised at paragraphs 80 and 81 of its judgment, which caused the judge to find the referral of the agreement was a sham. One of those was the bribe, but there were also, which it mentions at paragraph 81, there were also the other reasons at paragraph 80. And so even if Mr Azima could show that he had introduced the buyers to the transaction, the Court of Appeal has already ruled that would not have had an important influence on the deputy judge's findings in respect to the unlawful conspiracy claim. And I'll come back to that when we come to look at the Project Beach reports that Mr Azima seeks to rely on, to say he now has fresh evidence to show that the deputy judge's findings in respect to the unlawful conspiracy claim was procured by fraud, because insofar as they relate to the unlawful conspiracy claim, Mr Azima relies on some passages in the Project Beach reports to suggest he did introduce the buyers to the hotel transaction, but the Court of Appeal, as we can see, has already ruled against Mr Azima on the point, and has said even if that was established, it would not have a material impact. And as the Court of Appeal was at pains to point out at paragraph 117, finally, in relation to Mr Nayebi's evidence, we take into account the prospects of a retrial after what has already been protracted litigation. We place considerable weight on the principle of finality, and we say that that is a theme that underscores the orders that the Court of Appeal came on to make. And then if we drop down the page to paragraph 122, we can see the second passage where the Court of Appeal emphasised that the deputy judge's findings of fraud against Azima should stand, irrespective of the outcome of the hacking counterclaim. The earlier passage was 63. At paragraph 122, the Court of Appeal says, we consider that the attacks on the judge's findings of fact in relation to RAKIA's claims fail, and that even if RAKIA was responsible for the hacking, those claims should not be struck out or dismissed. And the Court of Appeal, having dismissed Mr Azima's argument based on equitable set-off, repeated that point a third time at paragraph 128 on page 31, where it said, accordingly, we consider that irrespective of the outcome of the counterclaim, the judgment in RAKIA's favour on its claims must stand. The Court of Appeal then turned to consider what to do about the hacking counterclaim, which the deputy judge had dismissed. At paragraph 129, it says, if the judge had found that RAKIA had been responsible for the hacking, in theory, the counterclaim might have been either wholly or partly valid. We turned then to consider the hacking claim, but only in the context of the counterclaim. The Court of Appeal then turned to consider the fresh evidence that Mr Azima wanted to adduce to argue that RAKIA was responsible for the hacking. Paragraph 134 on page 32, the court noted that whether RAKIA was involved in the hacking of Mr Azima was hotly in dispute, and that there were some inconsistencies between the fresh evidence Mr Azima was seeking to adduce and Mr Azima's original case on how the hacking had been conducted. And at paragraph 135, the Court of Appeal then said, what the court should do when a contested allegation is made that a judgment was procured by fraud has been the subject of some case law. There are, in essence, two alternatives. The first is that the litigant alleging the fraud may bring a separate action to set aside the judgment. The second is that the court may direct a trial of the fraud issue within the existing action. The Court of Appeal then referred to the Supreme Court's judgment in Takar and Gracefield and Lady Justice Aspin's recent decision in Dale and Bangor, and we can pick it up again at page 34, paragraph 140, where the Court of Appeal noted that Mr Lord argued, particularly in his reply, that despite the radical change in account of how the hacking had come about, the Court of Appeal should not order a retrial, but should instead find that RAKIA was indeed responsible for the hacking. And at paragraph 141, the Court of Appeal declined that invitation. It said, in our judgment, the fact that there are at least two mutually inconsistent accounts of how the hacking came about means that it is not safe to reach any conclusion without a re-evaluation of the evidence. The new case will have to be pleaded and proved in the usual way. And then at paragraph 142, the Court of Appeal said this, the question then arises whether we should remit the issue of fraud to the High Court within the existing proceedings or leave Mr Azima to begin a fresh action. Not surprisingly, Mr Lord argued for the first alternative and Mr Tomlinson for the second. And just pausing there, we saw those arguments and how they were put to the court in terms of jurisdiction, service, cost, delay, efficiency and fairness. Those arguments are then summarised by the Court of Appeal at paragraphs 143 and 144, and at paragraphs 145 and 146, the Court of Appeal then expressed its conclusion. And this is the important passage. At paragraph 145, it said, we are narrowly persuaded that remission of the hacking claim would be more expeditious and less costly than leaving Mr Azima to begin a fresh action. We agree with Mr Lord that it would place the Deputy Judge in an invidious position if he had to revisit all his findings of fact on the hacking claim, and therefore the remission will have to be to a different judge of the Chancery Division. And then importantly this, remission in the current action also has the benefit that RAKIA's judgment against Mr Azima on its claims will stay in place, irrespective of the outcome of the counterclaim. So just pausing there, this is the fourth time the Court of Appeal has said that RAKIA's judgment against Mr Azima must stay in place. And crucially, this is in the context of the question of whether to remit or dismiss the appeal that allow Mr Azima to commence fresh proceedings. The Court of Appeal is narrowly persuaded to order remission precisely because the Court of Appeal can then order how that remission is to be structured, as we will see in the next paragraph. And it can direct what architecture should be retained from the earlier judgment, in the words of Mr Lord Casey when he was making his submissions on the Bank of St Petersburg type of remission. And the Court of Appeal believes it would be more appropriate to adopt that course than to allow Mr Azima to commence fresh proceedings, because there is a benefit, it sees, to retaining some of the architecture from the original proceedings.
Just a little bit of that submission that I haven't quite grasped properly. I don't see in the judgment that you're taking us to at the moment, the Court of Appeal are contemplating allowing or not allowing Mr Azima to make a fresh claim. They seem to be saying they're leaving it to him to make a fresh claim, but you're putting it on the basis that he needed their permission to bring a fresh claim, which I haven't understood.
No, my lord is right. They're not saying that he can't bring a fresh claim in those terms, but they're saying that there were options available. That's what the law shows. Mr Azima had argued for remission, and the Court of Appeal decides that it would be more in accordance with the overriding objective to order remission, particularly because that has the benefit, this is what they're saying at 145, that you can retain some of the architecture from the original proceedings, because they can give directions that it must stand.
No.
Then they're not, I accept my Lord's point, they're not saying in terms that Mr Azima can't also then bring a fresh claim, but we're saying it would be surprising if the court did contemplate that he could do that, because that would then upset the structured remission that they go on to order. If they are ordering that the judge's judgment on the main claims must stand, it's going to cut across that completely if Mr Azima is allowed to bring fresh proceedings.
Well, I'm not sure about that. That's what I find that rather difficult to follow, because the Court of Appeal, the as it were, the sort of structured approach that's adopted could have been adopted either way, couldn't it? I mean, they could have said, yes, you can bring a fresh action, but you won't be allowed to challenge the main claim in that fresh action. And
Yes.
if the Court of Appeal had said that, subject to the issues that we have to debate in this appeal,
Yeah,
if the Court of Appeal had said that, that would be the beginning and the end of it.
that could have been
it
another
wouldn't really
way.
matter whether it was remission or a fresh action, I think is the point.
It might have given rise to difficulties outside the action if additional parties were involved. I mean, the benefit of remitting in this action, it now means that because we've been brought in as additional parties to this action, we now have the benefit of the judgment being retained. If there had been fresh proceedings, it would have been harder to direct that those proceedings would necessarily have had an impact on third parties. But I completely take the court's point that they are not expressly saying that Mr Azima should be precluded from bringing a fresh action. But we say that is the reason they're adopting this route is that they see there being a benefit to there not being relitigation about the findings of fraud. They see a real benefit to the findings of fraud against Mr Azima standing, irrespective of the outcome of the hacking counterclaim. And they have given cogent public policy reasons for that. It's the reasons that they had given earlier, that the hack material should have been disclosed by Mr Azima in any event. Those materials showed that Mr Azima had committed numerous frauds, and to set aside Azima's claims, the RAKIA's claims against Azima, would be allow Mr Azima to hang on to the fruits of his wrongdoing. And the better sanction, if he succeeded on his hacking counterclaim, is to allow him damages if he can prove damages, and or to revisit the awards of interest and cost. And there was also the public policy in respect to finality that pointed in the same direction. Paragraph 146, the Court of Appeal then clarified how the remission was to work. It says this: having reached that conclusion, we do not propose to deal with Mr Lord's more detailed criticisms of the judge's handling of the evidence. Suffice it to say that to the extent those criticisms were well-founded, they could only have led to a retrial of the hacking claim. This court would not have substituted its own findings of fact for those of the judge. And then this: we should also make it clear that neither the parties nor the judge who hears the remitted issues will be bound by any findings of fact made by the judge on the hacking claim. But his findings of fact on RAKIA's substantive claims stand. It will be for the Chancery Division to give directions about the future conduct of the hacking counterclaim. So we say that the Court of Appeal was ordering a structured remission to the new Chancery Judge. The Court of Appeal was making it clear that while the new Chancery Judge would not be bound by any of the findings of fact made by Judge Lennon on the hacking claim, the new Chancery Judge would be bound by the findings of fact made by the Deputy on RAKIA's substantive claims, namely the finding that Mr Azima had defrauded RAKIA. And we say that if Mr Azima is now given permission to bring fresh set-aside proceedings, having previously argued strenuously against that course of action, he will be doing that which the Court of Appeal has said should not be done, irrespective of the outcome of the hacking counterclaim. Namely, he will be trying to set aside the Deputy Judge's findings of fact on RAKIA's substantive claims. And finally, at paragraph 148, the Court of Appeal explained in further detail the relief they were granting to Mr Azima. The Court said this: following the circulation of this judgment in draft and in light of the parties' comments, we think it appropriate to clarify the relief that we give in relation to grounds 5, 6A and 6B. Ground 5 wraps up 3 separate points. A, whether the judge should have found RAKIA was responsible for the hacking. B, if he had so found, whether he should have excluded the evidence obtained as a result of the hacking, and or C, that having so found, he should have struck out RAKIA's claim. We've decided B and C in RAKIA's favour, pausing there, i.e. even if RAKIA was found to be responsible for the hacking, the evidence should not be excluded, nor should the claims be struck out. Because we are remitting the hacking counterclaim in light of the fresh evidence, we cannot allow or dismiss the appeal on ground A. So that point was parked. Grounds 6A and 6B suffer from a similar defect. They are certain that in view of the new evidence, A, RAKIA should be found responsible for the hacking, and B, that the consequences in grounds 5 and 6 should follow. We've decided the consequence in ground 5 does not follow, even if A is decided in Mr Azima's favour following a new trial, i.e. even if RAKIA is found following the new trial to be responsible for the hacking, the evidence should not be excluded and its claims should not be struck out. And then they went on, ground 6 refers to the judge's dismissal of the counterclaim which we have set aside. Once again, we're not in a position to rule definitively on A, i.e. whether RAKIA was responsible for the hacking. All that we have done in relation to the fresh evidence is to admit it on the appeal and to remit the hacking counterclaim for retrial. In light of the way in which these grounds of appeal are drafted, it is probably better to deal with our conclusions by way of declarations. And that then leads to the order that the court...
Just pausing there, the reference to A, whether the judge should have found that RAKIA was responsible for the hacking, and the Court of Appeal saying that in effect, that they're not going to deal with it. Is that picking up the same point as they're making in the first two sentences of 146, where they talk about Mr Lord's more detailed criticism of the handling of the evidence?
Yes, and I think it's picking up the point they'd made earlier.
Could only have led to a retrial of the hacking.
Because there are two inconsistent accounts put forward on the appeal of how the hacking came about.
This is only dealing with the evidence of the criticism of the evidence in relation to the hacking counterclaim.
Correct. They've already dealt earlier with grounds 7 and 9, which were the criticisms on the underlying fact.
Yeah. Okay.
And that then leads to the order that the Court of Appeal made, which we have behind tab 12 in the supplemental bundle. And if we turn to the second page, the main body of the order, we can see how it is structured. Paragraph 1 admitted the fresh evidence in relation to the hacking counterclaim, and paragraph 2 set aside Deputy Judge Lennon's order dismissing the hacking counterclaim. But notably, no other part of Deputy Judge Lennon's order is set aside. Paragraph 3 remits the hacking counterclaim to the Chancery Division to be tried by a new judge. And then importantly, paragraph 4 says this: in respect of ground 5, i.e. the ground seeking to strike out RAKIA's claims or to exclude the illegally obtained evidence, it is declared, so this is the declaration the Court of Appeal was referring to, that even if it is established on the counterclaim that the respondent was responsible for the hacking and dissemination of the appellant's data, A, the evidence obtained as a result of the hacking should not be excluded, and B, the respondent's claims against the appellant should not be struck out. So the Court of Appeal is declaring even if Mr Azima succeeds on his counterclaim and establishes that RAKIA was responsible for the hacking, and even if RAKIA's witnesses are found to have lied about the hacking, as the Court of Appeal had made clear in its judgment, the Court of Appeal was declaring the Deputy Judge's judgment in RAKIA's favour must stand. And that is what the Court of Appeal intended is also clear from paragraph 12 of the Court of Appeal's order, where the Court of Appeal sets out very clearly what was and what was not up for grabs if Mr Azima succeeded on his hacking counterclaim. At paragraph 12, the Court of Appeal said, in the event that the respondent succeeds on his counterclaim, A, paragraph 1b of the High Court order is set aside. My lords, that was the Deputy Judge's award of interest. And the question of any interest on damages awarded to the respondent shall be in the discretion of the nominated judge. And B, paragraphs 3 to 7 of the High Court order are set aside. Those were the paragraphs in the Deputy Judge Lennon's order dealing with costs, my lord. And the questions of costs of the respondent's claim against the appellant shall be in the discretion of the nominated judge. And that is it. Nothing else in Deputy Judge Lennon's judgment was to be set aside, even if Mr Azima succeeded on his hacking counterclaim. So just as the Court of Appeal had indicated in its judgment, even if Mr Azima succeeded on his counterclaim, Deputy Judge Lennon's judgment on RAKIA's claims against Mr Azima would stand. And the only parts that could be revisited were those parts dealing with the award of interest and costs. And standing back, we say that the Court of Appeal really could not have been more clear. As it repeatedly emphasised, even if Mr Azima succeeded on his hacking counterclaim, RAKIA's judgment must stand. We say the Court of Appeal meant what it said. It had reached that conclusion for a number of cogent reasons of public policy. The documents that had been obtained by the hacking should have been disclosed in any event. Those documents clearly demonstrated that Mr Azima was a serial fraudster who had forged documents, paid bribes, received secret commissions, and had sought to cover up and lie about his conduct both to RAKIA and to the court. And he had persisted in those lies even in the face of the documents. And in those circumstances, there was a strong public policy in ensuring that Mr Azima did not benefit from the fruits of his misconduct. That public policy consideration outweighed the court's concern to protect the administration of justice. And there were other ways in which the court could mark its displeasure of RAKIA's misconduct in the event in due course it was found that RAKIA was responsible for the hacking, such as revisiting the awards of interest and costs and reducing or removing those, and permitting Mr Azima to advance his counterclaim for the hacking. But beyond that, they said the judgment of Deputy Judge Lennon that had been handed down in RAKIA's favour on Mr Azima's fraudulent misconduct should stand, and the public policy in the interests of finality also came down firmly in favour of that conclusion, rather than allowing there to be a full retrial of the original action. And we say the Court of Appeal struck a careful balance between the conflicting public policy interests. It's not for this court, obviously, to query whether they got the balance right or wrong. It's to assess what balance they were striking and what they have ordered. And we say what Mr Azima is now trying to do, having tried unsuccessfully to appeal the Court of Appeal's judgment, is to upset that balance by expanding the scope of the remitted action, contrary to what the Court of Appeal previously ordered, to set aside a judgment in RAKIA's favour on Mr Azima's frauds.
Can I just test the limits of where you go on this?
Yeah.
Suppose that Mr Azima had appealed without alleging fraud at all, and the appeal had been dismissed. You wouldn't suggest that that had barred him from coming back with evidence of fraud and seeking to set aside Mr Lennon's judgment, presumably?
Correct, my lord.
Suppose Mr Azima had appealed relying in part on supposed evidence of fraud, nothing to do with the materials that are now relied on, and that appeal had been dismissed. Would that, on your case, have prevented Mr Azima from applying to set aside for fraud?
No, my lord. If there was qualitatively different evidence of fraud that emerged, that would not prevent him. And I'm coming on to look at
Yes.
this.
So I think what will be said against you is that the Beach reports are qualitatively different
And I'm going to come on
evidence
to that.
in a way in which what might be described as the hacking evidence. I
Leeches and
follow the point that merely having more material that demonstrates that RAKIA was behind the hacking can legitimately be said to be more of the same, if I can put it that way. But what's said against you is that the Beach reports are really in a different category altogether. They're not really, I mean, they may be the fruit of hacking, but they're internal reports within RAKIA and its advisors.
and I will come to that and look at the Beach reports to say why they don't in fact have that effect. There are two short reasons. I mean, one could take the example, for example, that whether the Project Beach reports show evidence that RAKIA knew that Mr Azima had effected the introduction to the buyers of the hotel. Well, there are 2 points in answer to that. First, the Project Beach reports do not in fact go that far.
No.
But second, even if they did, the Court of Appeal, as we have seen, has
Well, I
already
understand that
decided
But it's really
the misrep
the
claims.
point I think that troubles me, at least, it maybe troubles the court generally, is to do with the reliance point, really.
And I'll make that good as well, because in fact, the reliance arguments aren't advanced either by the Project Beach reports. But can I come back to that in just a
Yeah,
moment?
of course, of course.
Because sequentially what happens next is the appeal to the Supreme Court.
And
So
just before you
yeah.
move on,
No, of course.
it's supplemental to the earlier answer. So we're now supposing, or I'm now supposing, that Mr Azima has appealed relying on supposed fraud unconnected with what we're now talking about.
Yes.
And the appeal has been dismissed. And you say, well, that would be qualitatively different, therefore Mr Azima could apply to set aside for fraud.
Yeah.
Would it make any difference if the Court of Appeal in its order had not merely dismissed the appeal, but made a declaration that all the findings contained in the original judgment should stand?
No, because if there's been a material change in circumstance, I would accept that there is no abuse, so that the court can reopen. The question is, as we'll come on to, whether there has been a material change in circumstance. As I say, it's a staged argument. You have to first consider what the Court of Appeal has decided, and then whether there's been a change in circumstance. And the first point leaches into the second to this extent. If the Court of Appeal has said that the judgment against in RAKIA's favour must stand irrespective of the outcome of the hacking counterclaim, it follows that even a win on the hacking counterclaim couldn't in and of itself be a material change in circumstance, because they've contemplated that. It's got to be qualitatively different to what was argued before and that which the Court of Appeal has ruled on. And I'll come on to explain why that is true, not just for the hotel transaction, but also on the representation points.
Mr Mesmer, can I ask a different question?
Yeah.
It's on the effect of the Court of Appeal's order.
Yeah.
You don't need to tell me the answer now, but can I just tell you that I don't understand why your client is bound by the decision, by the findings in the first judgment to which it wasn't a party. Your client wasn't at the first trial.
No, but when that...
The Court of Appeal have said it stands, I get that,
Yes.
but you weren't a party to that order either,
But
and I don't understand why you're
But we're now brought into the same proceedings.
Well, I know you are, but why does that mean you're bound by the findings in that
In
judgment?
these proceedings,
Well, your
yes,
argument really is that Mr Azima's bound.
we
by
want
it,
Mr
not
Azima
you.
to be bound,
Well,
exactly.
I know you do,
Yeah.
but the consequence would be you would be bound, and it doesn't feel right to me to think that you are bound, and if you're not bound, I don't understand why
Mr
you
Azima
take the
should be.
benefit with Mr Azima.
Let me have a think about that, my lord, but I think our position is that we are, if the Court of Appeal has said in the hacking counterclaim that's being remitted, those findings are binding on the judge, then because we've been brought into those proceedings, we will be bound by them, and so will Mr Azima.
But it's really the argument about abuse of process, isn't it?
It is.
That I mean, the judge has decided that you had locus standi to raise the issue of abuse of process, notwithstanding that RAKIA had pulled out of the action. There's no appeal from that finding.
Correct.
There's a cross appeal from that finding.
And our interests are engaged, as I hope I explained at the outset of the submissions today, because if the judgment is to be set aside and we don't have the benefit of it, if there's even a risk of that, we are going to have to traverse in the trial the same points that were traversed in the original action to prove over again that Mr Azima was indeed a fraudster and committed all these wrongs, so that we can run the arguments we want to run, both on liability and on quantum.
I'm still a bit bothered by that. I mean, A, you weren't involved in the first trial, so there's no question of you being vexed again. You're not having to do all the work again. But B, what would have happened if Mr Azima had simply brought a fresh claim against RAKIA to set aside the judgment? You wouldn't have been a party to it. So suppose that had happened, could you have insisted on the findings and the judgment standing for your purposes?
Not if the Court of Appeal hadn't made the directions that it did, because the reasons that we're saying that it's an abusive process is because the Court of Appeal didn't go down that route. Instead, they ordered a structured remission and made declarations that findings would stand. So we're not in that hypothetical situation. I understand my lord's point that would things have been different, but the Court of Appeal ordered what it did. And our concern is that it did so for the reasons we've looked at. And it having ordered that, we say it is an abusive process to go behind that, unless there's been a material change in circumstance.
So is it there crucial that the Court of Appeal included paragraph 4, for example? I mean, if the Court of Appeal had simply dismissed the appeal, except as to the hacking claim, what would the position have been then? If, supposing that Mr Azima had then brought independent proceedings to set aside the original judgment?
If it had done that, I don't think I would be before your lordship today saying, given what it's ordered, Mr Azima is banned. But it didn't do that. Instead, it went for the remission route. And it made very clear when remitting that certain findings must stand. And we say they must, irrespective of the outcome of the HAKIA counterclaim. That's the phrase the court uses, unless there's been a material change in circumstance. Further evidence of the hacking doesn't constitute a material change any more than the win on the hacking would. The question is whether evidence comes out of the Beach reports that goes just beyond the hacking and starts infecting the underlying merits in a way the Court of Appeal hadn't already contemplated. And we say, for reasons I'm about to come on to, that it doesn't. Was there anything else the court wanted to raise before I move on from that? I appreciate it. I'm grateful.
Yeah.
Now, it's not just us who say that that is how the Court of Appeal's judgment is to be interpreted, that the claim should stand. It was also, in fact, precisely the way in which Mr Azima put his case when he tried to get permission to appeal the Court of Appeal's judgment from the Supreme Court. And can we look very briefly at that before I come to the Project Beach material? We have Mr Azima's application for permission to appeal to the Supreme Court in Supplemental Bundle Volume 2, behind tab 13. And we can pick it up at page 29, behind tab 13.
What's the status at this point, Mr. Is it really no more than a... I hesitate to say a jury point, because that sounds rude, but it's what's I'm trying to make you not in copy. You know, this is
it's showing that other people have
all
thought this was the construction.
Yeah, all right. The judgment
we've interpreted the judgment this way, and Mr Azima has in the past, and we say he was quite right about that. It's a very short point.
It's a limited.
I understand that the issue for this court is whether we're right about it, whether Mr Azima was right about it. Doesn't matter how many of us say it, but
anyway, as you say, it's a short point.
It's a short point. It's page 29, behind tab 13, paragraph 45 of the proposed grounds for appeal, where Mr Azima says this: the central focus of the appeal is that despite remitting the hacking issue for retrial, the Court of Appeal preemptively determined that even if RAKIA was responsible for the hacking and had systematically deceived the court, the possible remedies were confined to the counterclaim and a reassessment of interest and costs. And just pausing there, we completely agree with that analysis of the Court of Appeal's judgment. That was precisely what the Court of Appeal ordered. Mr Azima went on, put differently, regardless of how serious RAKIA's wrongdoing and deceit may be shown to have been, 1, the judge hearing the retrial will be unable to strike out RAKIA's claims for abuse of process. 2, the judge hearing the retrial will have no power to exclude any of the evidence illegally obtained, including privileged documents. 3, RAKIA's wrongdoing will not impact its claims, even though they depended in key aspects on the credibility of its count. And 4, Mr Azima's defence of equitable set-off will be dismissed. And we respectfully agree once again with that analysis. That was exactly what the Court of Appeal had said in its judgment and its order. Mr Azima was right to say that that was what the effect of what had been ordered, and is wrong to suggest otherwise now. And furthermore, when advancing his application for permission to appeal to the Supreme Court, Mr Azima sought to adduce yet further fresh evidence on the hacking, and that took the form of 2 affidavits, one from Mr Page and Mr Halabi. We have their affidavits behind tabs 14 and 17 in the supplemental bundle. And in short, Mr Page claims to have commissioned the hacking at the request of the ruler, to have lied about it previously and given false evidence to the court. And he says that some of the other RAKIA witnesses knew about the hacking and also conspired to cover it up from the court. And Mr Halabi also claims to have given false evidence previously to the court about the circumstances in which the hacked materials were supposedly found. And he also claimed he was persuaded by some of other RAKIA's witnesses to put forward that false account. Now, that evidence was lodged by Mr Azima with the Supreme Court on the 10th of January in the case of Mr Page's evidence, and the 3rd of February of last year in the case of Mr Halabi's evidence. And RAKIA objected to that fresh evidence. It's worth looking briefly at RAKIA's objections. we have the objection to Mr. Page's evidence at tab 16, which RAKIA filed on the 17th of January. And at paragraph 4, supplemental bundle, tab 16, page 8, RAKIA said the Court of Appeal's decision was based on the judge's conclusions about the seriousness of Mr. Azima's fraudulent conduct towards RAKIA, which Mr. Azima did not seek to challenge before the Court of Appeal, and on the fact that even if RAKIA had been responsible for the hacking and had presented a false case about this, this would not affect the fact that RAKIA's claims against Mr. Azima were fundamentally meritorious. RAKIA referred at paragraph 4a to the passages in the Court of Appeal's judgment where the Court of Appeal had noted that the hacked documents revealed serious fraud on the part of Mr. Azima, and at paragraph 4b to the passages in the Court of Appeal's judgment where the Court of Appeal had said any unlawful conduct by RAKIA was peripheral to its claims, and made the point at paragraph 5 that the Court of Appeal had held that even taking Mr. Azima's case at its highest, it would have been wholly disproportionate to have struck out RAKIA's claim, leaving Mr. Azima with the fruits of his fraudulent misconduct. And at paragraph 6, RAKIA said there was nothing in Mr. Page's affidavit that undermined the basis for the Court of Appeal's conclusions on those issues. And they also filed an objection to Mr. Halabi's evidence at tab 19, which we have, if we turn behind tab 19 to page 8, paragraph 5, RAKIA said, in this regard, it's important to emphasize the Court of Appeal's order, which is the subject of the proposed appeal, provides that even if it is established on the counterclaim that RAKIA was responsible for the hacking and dissemination of the appellant's data, the evidence obtained by the hacking should not be excluded, and RAKIA's claims against Mr. Azima should not be struck out. It logically follows that fresh evidence concerning RAKIA's alleged responsibility for the hacking has no bearing on the correctness of a conclusion which was already expressly premised on the possibility that RAKIA was responsible for the hacking. And again, we would agree with RAKIA's analysis. That was precisely what the Court of Appeal had ordered, and explains why it would be wrong for Mr. Azima to seek to rely on the evidence that emerges in the course of the hacking counterclaim, unless it is of a qualitatively different nature to the original hacking claim. And then if we turn forward to tab 20, you can see the upshot, which is that in the event on the 28th of April last year, the Supreme Court refused Mr. Azima his application for permission to appeal on the basis that it did not raise an arguable point of law. And we say that that should have been the end of the road for Mr. Azima, but it was not, because less than 6 months later, on the 30th of September of last year, Mr. Azima issued an application in the remitted chancery proceedings by which he sought to expand the proceedings to allow him to bring an additional counterclaim in which he seeks to set aside the deputy judge's judgment in RAKIA's favour on the grounds that they were procured by fraud. And in doing so, Mr. Azima has sought to advance the same arguments, we say, that he tried unsuccessfully to advance before the Court of Appeal. Mr. Azima says now, as he said previously, that RAKIA has procured the Lemon judgment by fraud. In particular, he suggests there has been a massive and pervasive dishonesty involving all of RAKIA's witnesses. It's his case that RAKIA procured the hacking of Mr. Azima, that Page and Halabi and probably others had conspired to give false evidence about how they came across the hacked material, that Mr. Buchannan and Mr. Gerrard had between them created a false paper trail through an exchange of emails purporting to break the news about the discovery of the Azima material, and that the ruler has also given false evidence. And Mr. Azima seeks to suggest that this contaminates and prejudices the outcome of the original trial, with the result that the Lemon judgment should not be allowed to stand, but should be set aside. But none of those factors in and of themselves constitute a material change in circumstance which might justify what Mr. Azima is trying to achieve via a different procedural route to that which the Court of Appeal has previously said he must not do. Mr. Azima has already advanced those arguments to the Court of Appeal, as I've shown the Court, and the Court of Appeal has found against him and said that even if he succeeds on his hacking claim, and even if he establishes that at least some of RAKIA's witnesses lied to the court and covered up the hacking, nonetheless, the claims against him should stand. And the Court of Appeal must have anticipated, when it remitted the hacking counterclaim to be heard afresh, that evidence might emerge that would support Mr Azima's case on the hacking. It would support his argument both that RAKIA was responsible for the hacking and that RAKIA's witnesses had given false evidence to the court. But nonetheless, the court said the claims against him must stand. Now, beyond those generic arguments that RAKIA's witnesses had lied about the hacking and therefore their credibility should be set at naught, Mr Azima also seeks to make some specific points based on the Project Beach reports that he's now obtained via Mr Page, based on which he seeks to argue there's now important fresh evidence which does not just go to the hacking, but to the underlying merits of the dispute. And in particular, Mr Azima seeks to argue, first, that some of the Project Beach reports suggest that he did introduce the purchases to the hotel transaction and that the referral agreement was genuine. Second, that some of the Project Beach reports suggest that RAKIA already believed that Mr Azima had acted wrongfully against RAKIA when it entered into the settlement agreement. And third, that some of the Project Beach reports suggest that RAKIA already had access to materials relating to the Heavy Lift Training Academy joint venture when it entered into the settlement agreement, and that the settlement agreement was a trap. And the problem for Mr Azima with those
Sorry,
arguments...
just repeat that last point.
The third point is that some of the Project Beach reports suggest, so he says, that RAKIA already had access to the financial materials relating to the Heavy Lift Training joint venture when it entered into the settlement agreement, and he seeks to argue that the settlement agreement was a trap designed to get him to make an express good faith representation, which would then bring him within the jurisdiction.
Yeah.
And the problem for Mr Azima is firstly that the Project Beach reports do not in fact go as far as he would like them to go, but secondly, and perhaps more fundamentally, these are not in fact new arguments, so I'll show the court. On the contrary, Mr Azima has already tried, unsuccessfully, to run substantially the same points before the Court of Appeal and before the Deputy Judge, and the arguments were rejected as having no merit then, and they have no merit now. Indeed, they are just further evidence of abuse of Mr Azima seeking to run points which he has already fought and on which he has already lost. And if I can make that submission good, can we start with Mr Azima's claim that the Project Beach reports show that he had introduced purchases to the hotel transaction and that this would have had a material impact on the judge's determination of the unlawful means conspiracy claim. As I say, there are two problems with that argument for Mr Azima. And the first problem is when you actually look at the Project Beach reports, none of them say in terms that Mr Azima had in fact introduced the purchases to the hotel transaction. The Project Beach reports say that Mr Azima was deeply involved in the transaction. We can see that, for example, if we turn to tab 27 in the supplemental bundle, page 3, MASB 27, page 3. Yeah, and if we go down the page, sorry, back to page 3. Yes, it's the first paragraph. Our source has reported back that Azadeh has found and delivered back to FA, that's Farhad Azima, that the Sheraton Hotel had a mortgage during the transaction in 2011, where Farhad Azima was deeply involved. So it refers to him being deeply involved in the transaction. There are also references that he was the mastermind behind the deal. You see that at tab 33, page 2, and that Mr Azima knew about a dispute between the buyers.
Sorry, tab 33.
Tab 33, page 2, paragraph 7. Our US source has uncovered that FA is the mastermind behind Torian Nayebi in relation to the Sheraton Tbilisi Hotel deal. And there's another report at MASB 29, page 4, that Mr Azima knew about a dispute between the buyers from the first day.
Sorry, I wasn't keeping up again. That was
I'm sorry,
tab 24.
Tab 29,
Tab 29.
page 4.
Yeah.
For your information, Mr Farhad knows from the first day, and what's being referred to there is his knowledge of a dispute between the buyers. It's not saying that he knew about the transaction from the first day. But just pausing there, no one has ever disputed that Mr. Azima was heavily involved in the hotel transaction. And the judge, as we saw in the trial, referred to photographs, meetings, and emails which showed that he was. What was disputed was whether Mr. Azima had, as he claimed, effected an introduction, or whether the purchasers were already on the scene, as was stated in the Adams Memorandum. Now, one Project Beach report, dated 23rd of May 2016, states that following revelations in the Panama Papers, at least 2 media outlets would link Mr. Azima to Dr. Massad and the Sheraton deal and RAK as the one who made the introduction between the parties and cut a 5% fee. That's Supplemental Bundle tab 35, page 9. This is as close as one gets to any evidence that he involved the introduction. But when you actually look at what is...
Sorry, where are you on?
It's following the revelation of the Panama Papers. 2 media outlets, it's the second sentence, will soon link FA to KM, that's Dr. Massad, the Sheraton deal and RAK, as the one who made the introduction between the parties and cut a 5% referral fee. But that's simply recording what the press is intending to report. And if the press reported that, they would simply have been reporting what Mr. Azima had always claimed, that he had effected the introduction and cut a 5% deal. It doesn't show that it was true. Indeed, it can't have been true because it wasn't a 5% deal, it was a 2.5% deal. So we say, actually, when you look at the Project Beach reports, they don't contain a clear statement that Mr. Azima had effected the introduction. It just says, as was always the case, that he'd been involved in the transaction. But the second and more fundamental problem...
Just before you go on,
yeah.
You ought to disclose these, ought you? When I say you, RAKIA.
RAKIA should, to the extent that they bore on the issue of whether he had effected the introduction, yes, my lord. The evidence, as I understand it, I wasn't involved in the first trial, but the evidence, as I understand it, is that these reports were thought to have been destroyed and not to have existed. It turns out Mr. Page's secretary had kept a copy. I accept my lord's point. They should have been disclosed if they were relevant to the issues. They would show involvement in the deal. We wouldn't accept that they show that he effected the introduction.
But they could have been the basis for
that
cross-examination and argument.
I accept that, my lord.
Yeah.
I accept that. That's a fair point. But the second problem for Mr. Azima is even if the Project Beach reports went further than they do and say that he had effected the introduction, and that we understood that, the Court of Appeal has already ruled against Mr. Azima on that issue and said that it wouldn't have had a material influence on the Deputy Judge's decision. And we saw that when we looked at the Court of Appeal's judgment and what the Court of Appeal said when it refused to admit Mr. Nayevi's evidence as fresh evidence. In rejecting Mr. Nayevi's evidence, the Court of Appeal made it quite clear that even if Mr. Azima had introduced the purchasers to the hotel transaction, as Mr. Nayevi claimed, that would not have had a material influence on Deputy Judge Lemon's finding that the referral agreement was a sham. And we saw the reasons for that. There were a whole host of other reasons, quite independent, which the learned judge had relied upon in support of his finding that the referral agreement was a sham. I won't go back over those because the court has them firmly in mind. So the Court of Appeal has already definitively ruled against Mr. Azima on this issue and already said it doesn't matter if Mr. Azima can in fact show he introduced the purchasers. The referral agreement was still a sham and Mr. Azima was not entitled to the $1.5 million he received pursuant to it. Now finally on this point, Mr. Azima says a number of the Project Beach reports refer to the referral agreement itself, and it's right to acknowledge there are references in the Project Beach reports to the referral agreement, but none of them state in terms that the referral agreement is genuine. They're just references to the document purportedly recording the referral agreement, and to the extent they show anything, they just show that the author of the report did not suspect in 2015 that the referral agreement was a sham. And that's not surprising in our submission, because the referral agreement was only found to be a sham at the trial when the Deputy Judge, having heard evidence from Mr. Azima and Mr. Adams and considered the circumstances in which it was created, and having put the referral agreement under a forensic microscope, found that it had been fraudulently drawn up by those two individuals months after the event with the connivance and assistance of Mr Al-Sadek in order to try retroactively to justify the payment of 1.5 million Mr Azima had received. So we say references in the Project Beach reports to Mr Azima's involvement in the transaction or to the existence of a referral agreement don't in fact advance his case in any way. They're just, to the extent this is rerunning the point on the introduction, it's a rerun of an argument he's already fought and lost. Now, so far as the good faith misrepresentation claim is concerned, Mr Azima says that the Project Beach report show RAKIA in fact believed that Mr Azima had been engaged in wrongful conduct and could not have relied on the good faith misrepresentation. And the problem for Mr Azima, once again, is that the Project Beach reports do not go quite that far. They don't say definitively that Mr Azima has defrauded RAKIA. And furthermore, once again, he's already fought and lost on this point at trial. The Project Beach reports refer to Mr Azima being involved in potential criminal activity and several potential criminal activities. We can see that from the report in the supplemental bundle at tab 24, page 1. Where in about the fifth line down from the top of the page, it says, to do so, one of the main objectives is to point out any potential criminal activity by FA. So potential criminal activity, and one sees that again at page 36 in this report. Sees the reference to, in the first two lines, we believe the evidence and information gathered so far on the generator, that's reference to Mr Azima, show his exposure to several potential criminal activities. And another report refers to issues that might pose a criminal exposure for him. That's the Project Beach report at tab 30, page 6. You can just bring that up. Yeah, he says towards the bottom of the page, just below just above the last two bullet points, additionally, there are other issues that could be effective regarding FA's reputation and even pose him a criminal exposure. But the conclusions expressed in the Project Beach reports are qualified and tentative, as we've seen, and almost all of the misconduct referred to is references that one will see when you look at them to breach of the US sanction laws, the Patriot Act, which wouldn't have been actionable by RAKIA and wouldn't have demonstrated bad faith on the part of Mr Azima with regard to RAKIA, which was the important point. And the further point is that Mr Azima, as I've shown the court, had already run this point at trial. And that was because in the original proceedings, RAKIA did in fact disclose one of the Project Beach reports, the one which had survived, the Project Update report, which RAKIA quite properly disclosed, which suggested that prior to entering into the settlement agreement, RAKIA knew Mr Azima was cooperating with Dr Mossad in order to undermine and smear RAKIA, and was therefore acting in bad faith. And that was also borne out by another document, The View from the Window, which RAKIA had also disclosed in the earlier proceedings, which suggested that RAKIA had concerns that Mr Azima might have been involved in criminal and fraudulent activity. But the deputy judge dealt with this in his judgment, as Lord Justice Newey pointed out to me this morning at paragraphs 243 and 245 that we looked at. The reference again for the court is the supplemental bundle tab 1, page 78 to 79. And we looked at those paragraphs before. The judge notes that clause 3.2 of the settlement agreement expressly records the payment of 2.6 million is made in reliance on the good faith representation. He said that was a clear contemporaneous record, which Mr Azima acknowledged and endorsed of RAKIA's reliance. And he said it was consistent with the evidence of Mr Buchannan, which the judge then quotes, who said that although he was aware of the allegations being made about Mr Azima and concerns being expressed about his conduct prior to signing, he was reassured by Mr Azima's willingness to agree to the good faith wording. And the judge concluded that Mr Buchannan and the ruler had relied on the good faith representation, that while they may have harboured suspicions about Mr Azima, that did not negate inducement in such a case, and he relied on the decision of the Supreme Court in Zurich Insurance. So once again, Mr Azima has already fought and lost this exact point. And in fact, he didn't even seek to appeal that aspect of Deputy Judge Lennon's reasoning to the Court of Appeal, either on the facts or on the application of the Supreme Court's decision in Zurich Insurance. And we say that's not surprising because the Deputy Judge was quite right about that on the authorities. Finally, so far as the heavy lift misrepresentation claim is concerned, Mr Azima seeks to argue that the Project Beach report showed that RAKIA had significant information, financial information, obtained through the hacking about the sums that Heavy Lift had invested in the Training Academy joint venture, and that the Project Beach reports show that the settlement agreement was a trap. And again, the problems for Mr Azima are twofold. The reports do not in fact support that argument, and once again, it's a rehash of an argument on which Mr Azima has already comprehensively fought and lost. To the first point, the Project Beach reports do not show that RAKIA had significant information about the sums that Heavy Lift had invested in the Training Academy joint venture. What they in fact show is that RAKIA was aware of the balance sheet that Mr Adams and Mr Azima had prepared, which purported to show the simulator was worth in excess of $1.7 million, and that Heavy Lift had spent $450,000 on training aids, both of which Deputy Judge Lennon found at the end of the trial to be false. And one sees the false balance sheet set out in the report at tab 25 in the supplemental bundle, page 13. So this is appended to one of the Project Beach reports. And this is the main document that Mr Azima now points to say, aha, look, they had the information, they knew about the size of the investment, and therefore they can't have relied on what we were saying. But one sees that this purports to be the balance sheet on 31st December 2007, and there are various columns, the first of which is the Heavy Lift column, and is meant to record Heavy Lift's contributions to the joint venture. You see the simulator under property, plant and equipment. There's an entry, say 1.725 million for that, which is the sum that the judge found to have been a false sum for the simulator. And further down under other assets, one sees a reference to training aids, 450,000, which the judge also found hadn't in fact been bought. There was no evidence that any training aids had been bought. So what one sees is the false balance sheet with the false entries for the simulator and training aids, but there's nothing in the accompanying Project Beach report which shows the author had discovered, as the judge found, that in fact Heavy Lift had purchased the simulator for just $167,000, and that Heavy Lift had not in fact purchased or contributed any training aids to the joint venture, and that this entry was wholly fictitious. But it was those reasons why the judge upheld the Heavy Lift misrepresentation claim and found it to be false. And there's nothing in the Project Beach reports to suggest that RAKIA was aware of any of those points before it entered into the settlement agreement. As for the argument that the settlement agreement was a trap, the Project Beach reports do not in fact contain any statement that RAKIA intended the settlement agreement to be a trap. Rather, they record the view of Mr Azima's lawyer, Mr Kirby-Bear, that the good faith warranty seems like a trap. One can see that at the Project Beach report that we have at tab 29, page 1. And although Mr Kirby-Bear expressed that view at the outset of the negotiations, that it seemed like a trap, ultimately he expressed the view that it seemed as though Mr Azima had got out of the trap. One sees that in a subsequent Project Beach report at tab 34,
Sorry,
page 2.
You're going a little fast.
I'm
the
sorry.
First one is, don't worry.
So
The first one is what, tab 29?
tab 29, page 1.
Yeah.
It's point 4. KB, that's a reference to Mr Bear, the lawyer, is advising FA regarding the agreement last received from JB, that's Mr Buchannan, solving the Heavy Lift RAKIA dispute. According to KB, the agreement seems like a trap. And then in a subsequent report, which we have at tab 34, page 2, he expresses the
I want to
view.
make sure I've understood this. So this is January 2016, so that's before the agreement.
Yes.
So this shows that RAKIA knew that Mr Azima was being advised by his lawyer that
This was
like
it.
a trap.
So, yes, correct. And he was being advised immediately before the settlement agreement, Mr Azima appeared to have got out of the trap. And one sees that at the bottom of this page. In addition, Kirby Bear stated, although he believed that the agreement was a trap against FA.
Sorry, I've lost you again.
I'm so sorry, my
text.
lord.
I didn't keep up. So which
It's
page?
tab 34, page
Yep.
2.
Yep.
And it's the last sentence on that page. But in the event, the deputy judge already considered that argument in full in the first trial and comprehensively rejected it. Paragraphs 245 and 310 to 317 of his judgment. We just bring those up very briefly. So the judge's judgment is the supplemental bundle, tab 1, page 79. And the paragraph 245 on that page, he says, it's the last sentence, for reasons set out later in this judgment, I reject Mr Azima's case that RAKIA knew about the contents of the hack material and were inducing Mr Azima to enter the settlement agreement as a trap. And he's cross-referring there to paragraphs 310 to 317 of his judgment, which we have at page 99, MASB tab 1, page 99. And at 310, the judge records Mr Azima's case that RAKIA cynically entered into the settlement agreement as a device to trap him into agreeing a duty of good faith and an English jurisdiction clause, which with its access to the hack material would give RAKIA leverage over Azima. It would enable RAKIA to exact retribution for Mr Azima's failure to take RAKIA's side in dispute with Dr Massad and provide RAKIA with a means of turning Mr Azima against Dr Massad. And then at 311, the judge recorded Mr Azima's submissions, and he sets those out at some length at 311. And then if we go over the page, 312, he says his contention that entering into the settlement agreement is consistent with RAKIA having hacked his emails some 5 months previously and gives rise to an obvious objection. If, as Mr Azima alleges, RAKIA had by the end of 215 got access to his confidential emails and discovered evidence of what it now contends were his fraudulent activities, it is on the face of it inherently unlikely that RAKIA would have been willing to enter into the settlement agreement or to make payment to Mr Azima in settlement of the heavy lift claim. The fact that RAKIA had paid 2.6 million to Mr Azima under the settlement agreement suggests RAKIA was unaware of the contents of the hack material. Just pausing there, equally it's true if RAKIA has only seen the false balance sheet, then of course one can understand why it did go along and make the payment of 2.6 million. It doesn't show that the settlement agreement was a trap. Mr Azima's leverage explanation for the settlement agreement is not, however, compelling. RAKIA did not need to enter into the settlement agreement in order to sue or threaten to sue Mr Azima on the basis of the hacked emails. It could have sued him or threatened to sue him in relation to the fraudulent misappropriations in connection with the intended hotel sale without clause 3.2, although not in an English court. Moreover, there is no evidence RAKIA ever in fact attempted to use the settlement agreement or the hacked material to exercise leverage over Mr Azima. And then over the page at 315 to 317, the learned judge rejects the argument that the settlement agreement was a trap. So again, Mr Azima has already fought and lost on this point. There were compelling reasons why the judge rejected his argument. And again, he didn't seek to appeal that aspect of Deputy Judge Lemon's reasoning to the Court of Appeal. And the Court of Appeal has held that those findings must stand. So that was all I wanted to say on the Project Beach reports. As I said at the outset of my submissions, at its heart, this appeal gives rise to three questions. What did the Court of Appeal previously order? Is Mr Azima trying to achieve via a different procedural route that which the Court of Appeal has said he must not? Has there been a material change in circumstance? So far as the first question is concerned, you have my submissions. We say the Court of Appeal, both by its judgment.
Really sorry, Mr.
I'm sorry.
going very quickly, I get it.
Yeah.
You were showing us the settlement agreement paragraph in the judgment,
Yes.
and you said it stands, but it's part of the hacking claim.
But it's also part, because of the incorporation by reference, of the findings of fact. So the judge says at paragraph 245, where he's dealing with the issue of reliance, that it was Mr Azima's case that we didn't rely on the representations in the settlement agreement as a trap.
Is it treated as part of the hacking claim or part of the...
Because it's incorporated by reference, we would say it must stand, because the reasoning was relied upon expressly by the judge in resolving the reliance issue on the substantive claim in RAKIA's favour.
Yeah.
So, on the first question of what the Court of Appeal meant, you have my submissions. We say the Court of Appeal could not have been more clear that the judgment in RAKIA's favour that Mr Azima was a fraudster must stand whatever the outcome of the hacking counterclaim. That's what it expressly said at a number of points in its judgment. Not only that, it brought forward cogent reasons of public policy why that was the appropriate order to strike the balance between the parties. And Mr Azima, as we saw from his application to the Supreme Court, in fact understood perfectly well that that was what the Court of Appeal had ordered. So far as the second question is concerned, we say that Mr Azima is trying to achieve, by a different procedural mechanism, that which the Court of Appeal has said he must not do. He tried and failed to get permission to appeal from the Supreme Court, and having failed to get that permission, he is now seeking by his new set-aside counterclaim to achieve that which the Court of Appeal said must not happen. And absent a material change in circumstance, we say that is an abuse of process. That brings us then to the third question, which is whether there has been a material change in circumstance, and I've endeavoured to explain why there has not been. Mr Azima's case now is the same case which he previously advanced to the Court of Appeal and which Mr Lord put very high. It was his case that RAKIA was responsible for the hacking and that all of its witnesses had lied, that there had been a massive deception perpetrated on the court, and that called into question all of RAKIA's witness evidence and its evidence on reliability. The Court of Appeal had rejected those arguments, holding that even if there had been deception about how the hacked materials came into RAKIA's possession, that went to a collateral matter, and it didn't follow that RAKIA's witnesses were also lying about the substantive claim. And in remitting the hacking counterclaim, we say the Court of Appeal must have anticipated that evidence would emerge which supported Mr Azima's claims RAKIA was responsible for the hacking and that its witnesses had lied to the court. But even if that did emerge, and even if it proved decisive at trial, the Court of Appeal was still clear that the judgment that RAKIA had obtained should stand. And we say none of the evidence which has emerged and which Mr Azima now relies upon constitutes a material change in circumstances, bearing in mind what the Court of Appeal already ordered and the assumptions it was prepared to make in Mr Azima's favour. And finally, for the reasons I've just explained, none of the passages in the Project Beach reports which Mr Azima seeks to rely on would constitute a material change in circumstance, even if the reports said, and they do not, that Mr Azima had introduced the buyers to the hotel transaction. The Court of Appeal has already ruled in RAKIA's favour that that could not have a material influence on the Deputy Judge's judgment, and Mr Azima's arguments about their impact on the good faith misrepresentation claim and the heavy lift misrepresentation claim, we say are similarly misplaced. So for all those reasons, we would ask that the appeal be allowed and that Mr Azima be refused permission to bring his set-aside counterclaim on the grounds that it constitutes an abuse of process. And unless I can help your lordship further.
Thank you very much, Mr Macefield.
If I could just have a moment. Yes, I'm grateful to my junior. I understand I wasn't present at last week's hearing in front of Mr Justice Michael Green to consider what should happen in terms of the trial going forward. But I understand that at last week's hearing, Mr Thomas Pluman, KC, said that he accepted that until the Deputy Judge's judgment is set aside, they, i.e. the additional defendants, are entitled to rely on its findings. So partly to my Lord Justice Birss's comments, he's accepted that we are bound, and that appears to be...
Well, I think it was said, wasn't it, at some stage that the case should continue notwithstanding the appeal, and therefore that must follow from.
Yes, it was said to be based on the additional defendants being privies of RAKIA under Gleeson and Whipple 1977 One Weekly Law Report.
Yeah. Well, thank you very much, Mr. Macefield. I think we'll.
Lord, I think Bloomfield may slightly overstate that, but nevertheless it's of course true that in the context of last week's case management conference, I accepted that the argument would be that that Mr. Azima is bound by this judgment on the basis that it's protected by Henderson and the Henderson abusive process extending to privies, and that was the argument being made by Mr. Adam in Malone and Friends' position. I wonder if I can beg your indulgence to make one point, which I think shouldn't wait until tomorrow. I appreciate it's not my chance. There is still Mr. Pilbrow and Mr. White to go. But I think it is important that I say this, which is that Malone Friends Mr. Macefield has not referred you to the permission judgment, call bundle tab 10. The appellants sought and were denied permission to appeal on the finding of His Lordship Mr. Justice Green that the new evidence is material. They did not renew that application for permission to this court. The only ground of appeal before this court is the abuse of process ground, that's in call bundle tab 4. And in my submission, the overwhelming majority of the learned friend Mr. Macefield and his counsel's submissions today have been directed to materiality outside the scope of this appeal. He started, and I therefore didn't object, on the basis that understanding the judgment of His Lordship Mr. Deputy Judge Lennon would help to frame an understanding of what the Court of Appeal actually did, and therefore in some slightly ephemeral way help your lordships understand what the Court of Appeal intended objectively to do. But by the end, it was perfectly plain. What he seeks to do is to argue materiality, and in our submission that is outside the scope of this appeal. But I'll develop all of that
Well, we
tomorrow.
had that point well in mind, Mr. Bloom, and that there was no appeal on the issue of either fraud or materiality.
I'm grateful. I'm grateful. I apologise for interrupting at this stage. I just thought it right to say.
We'll take a break for 5 minutes.
My Lord, if I could just come back very briefly on that point, just 2 points. We didn't apply to appeal on materiality. We didn't seek and refuse permission on that. And the second point is I developed the points on materiality not in the context of whether there's a material case that the first judgment was procured by fraud, but in the context where there's been a material change in circumstances which would justify that which is not otherwise an abuse. That was the thrust of my submissions. That is plainly a matter that is within the ambit of the appeal. And our point is these points could potentially be material. We accept that. That's done and dusted. But the problem for Mr. Azima is that these points have been determined against him already by the Court of Appeal. So I endeavoured to show the court so that it is an abuse.
Yeah. Thank you very much. If we keep it to 5 minutes.
All right.
I must go back to your schedule. I'll go back to the schedule. I think it doesn't actually change it. I thought the schedule said that you did. It's Finn now, not you. Yeah, it's Finn next. Eh? Isn't there, what's their official time? In the Court of Appeal, 4:15, isn't it? Yeah, I mean, they may run late, of course.
That's true. Because you were out on that couple, I sent you. Make sure you work.
All rise.
My lords, I agree with my learned friend Mr Macefield that the key questions for the court on this appeal are the three he's identified. What is the effect of the Court of Appeal's judgment? Having understood that, is Mr Azima seeking, by a different procedural mechanism, to achieve precisely that which the Court of Appeal has refused to permit, indeed said must not happen, and if so, has there been a relevant change in circumstance? Those are the three key questions. And on those substantive points, your lordships have my submissions and my skeleton argument, and they've been covered at some length by my learned friend Mr Macefield, and I gratefully adopt his submissions. My learned friend Mr White will sweep up at the end for the appellants, and I preemptively gratefully adopt any points he picks up, sweeping up as well. And that will allow me not to traverse that ground again, which you've had laid out to you at quite some length this morning.
Yeah.
There was a temptation to go back just to take your lordships to the one additional paragraph in Mr Azima's Supreme Court complaint, in which he says in terms that the effect of the Court of Appeal's judgment has prevented him bringing an application to set aside on the basis the judgment was procured by fraud, which he would have been able to do had only he not brought the evidence forward on appeal. But my Lord the Chancellor's made clear that was a jury point, so I will leave you to read paragraph 54 of his application yourself.
Touche, Mr Pilbara.
So for my part, I will seek to restrict myself to certain legal points which arise, which for the reasons already canvassed and indeed already acknowledged by my Lord the Chancellor, are not the main attraction on this appeal. They're not the key points. but they need to be addressed nonetheless. So far as legal points are concerned, one should probably just get out of the way at the start the test that us, the appellants, have to meet on this appeal. And there's a potential hint in the skeleton arguments that there's a difference between Mr Pluman and us. I don't think there is, and if that proves to be, I can deal with it in reply. Because we both refer to the decision of the Court of Appeal in Harbour Castle and David Wilson Holmes, and the judgment of David Richards, Lord Justice David Richards as he then was. There's no need to turn it up. When one is dealing with an appeal on a question of abuse of process, because the assessment is fact sensitive and involves taking account of and giving appropriate weight to all relevant factors, an appeal court will not interfere with the judge's assessment unless the judge has taken account of irrelevant factors, ignored relevant factors, applied a wrong principle, come to a decision that was not properly open to the judge, or was, in the view of the appeal court, plainly wrong. So that panoply of 5 ways of putting essentially the same point, but that is what us as the appellants, in this case, have to meet.
It's a multifactorial judgment point.
Absolutely. And we say, dealing with that shortly, if we are right on the key points in this appeal, i.e. that which Mr Macefield has addressed you on this morning and earlier this afternoon, then frankly, each of those grounds will be made out. The judge will have failed to take into account a relevant factor, namely the true meaning and effect of the Court of Appeal's judgment. He will have taken into account an irrelevant factor, namely an incorrect interpretation of the Court of Appeal's judgment. He, by failing to give effect to the judgment of the Court of Appeal, he would have applied a wrong principle. And by permitting Mr Azima to do that which the Court of Appeal has said he must not be allowed to do, he would have reached a decision that was not properly open to him, it not being open to him to decide effectively that the Court of Appeal was wrong, and he would have reached a decision that was, quote, plainly wrong. So, with that, the test on this appeal cleared out of the way, what do I want to cover? Well, there were 3 authorities that are identified on the agreed pre-reading list, and therefore are probably considered to be key authorities. TACAR, Koshi, and Highland Financial Partners. Yeah. Now, my submission is that Highland Financial Partners is not in issue on this appeal, such that the 2 primary authorities I have to deal with are TACAR and Koshi. Why do I say that? The relevant point in Highland is as to the test for whether or not a judgment should be set aside as having been procured by fraud. A judgment will only be set aside as having been procured by fraud if, as the judge in his judgment labelled them below, in this case, the fraud condition and the materiality condition are met. Now, the correctness of that test is not an issue on this appeal. Indeed, it could not be, since the formulation of Lord Justice Aikens was expressly approved by the Supreme Court in TACAR. Nor is it contested that that test is made out, in this case, to the relevant standard required at the permission to amend stage, which was what was happening here. These were being brought in by amendment. The point being taken on this appeal is not, and this reflects the exchanges the court just had with my learned friend Mr Macefield, it's not that the judge was wrong to conclude that the fraud condition and the materiality condition have been made out to the relevant standard at the permission to amend stage only. The point being taken is, notwithstanding that the claim is capable of meeting the test to be permitted to proceed, it should still not be allowed to proceed, since it amounts to an abusive process, because it amounts to a relitigation of that which the Court of Appeal has already decided, to a collateral attack on or circumvention of that previous Court of Appeal decision. So, with respect, Highland is not in issue on this appeal, and I do not propose to address it. So that means the 2 main authorities that I have to deal with are TACAR and Koshi.
Yep.
TACAR, what it does, and crucially what it does not decide. Koshi, again, what it does and what it does not decide, and also why the judge's attempts in his judgment to distinguish it are wrong, and accordingly why it is an important case for the determination of this application and now this appeal.
Yep.
And I would like to address those 2 points, or address those points under 2 headings. One, the abuse of process principle itself, its breadth and its bases, and in particular the role therein of the principle of finality. And 2, fraud unravels all, the limitations of that principle and the extent to which it is not, or is not, a trump card in this case, which will involve addressing Takar and Koshi. So as your lordships will appreciate, that ultimately amounts considering each of the important and long-established principles of public policy that are, in this case, engaged in Lord Briggs's memorable phrase, in a bare-knuckle fight. And at the end of that, I'll seek to bring the points together in some final thoughts on this appeal. So, topic 1, abuse of process. Abusive process is, as Lord Bingham told us in Johnson and Gorwood, and has been repeatedly stressed since, a broad and merits-based jurisdiction. It is one in which there are no fixed limits or minimum criteria, but there is usually one common thread, which is finality. And I would like, if I may, to look quickly at certain of the authorities, none of which will be entirely unfamiliar to your lordships, but to do so for 2 purposes. One, to consider the question why finality is important, and 2, to consider the 2 interests which the law seeks to serve by and through its focus on finality. So, I'd like to take those authorities quickly and do it chronologically, and counterintuitively that means starting with Alsop and Banner-Jones, which is the most recent of them, but that's only because it's the best place to find in full the quotation from Lord Wilberforce in the Ampthill Peerage case. So that is the Authorities Bundle MAAB, tab 14, page 20. It's para 23 of the judgment of Mr Justice Marcus Smith, but we're going to it only because he sets out in full Lord Wilberforce in the Ampthill Peerage. MAAB 1420.
Sorry, paragraph.
So it's paragraph 23 of Mr Justice Marcus Smith, and I'm interested in his quotation in the paper from Lord Wilberforce, which is as follows. In English law, and it is safe to say all comparable legal systems, place high in the category of essential principles that which requires that limits be placed upon the right of citizens to open or to reopen disputes. The principle which we find in the Act of 1858 is the same principle as that which requires judgments in the courts to be binding and that which prohibits litigation after the expiry of limitation periods. Any determination of disputable fact may, the law recognises, be imperfect. The law aims at providing the best and safest solution compatible with human fallibility, and having reached that solution, it closes the book. The law knows, and we all know, that sometimes fresh material may be found, which perhaps might lead to a different result, but in the interest of peace, certainty and security, it prevents further inquiry. So that's quite content if your lordships agree to the end of his quotation if you wish, but that's what I wanted to take from. So finality is critical to the proper operation of and trust in the justice system. Litigation has to come to an end in the interest of certainty and to ensure the proper use of court resources. The entire purpose of the doctrine is to guard in the public interest against the abuse of the court's process. Now, if one steps forward to the year, this was 1977, Lord Wilberforce stepped forward to 2000 and Johnson and Gorwood, which we have in tab 4 of the bundle of authorities. Now, if we pick it up at page 22 of the bundle paging, page 22, that's where Lord Bingham starts his consideration of abuse of process, setting out some basic propositions, right of access to the court, but equally the court does not have to hear in full or rule on the merits of every claim or defence advanced. Quotes from Hunter, or Diplock and Hunter, and then over the page, Henderson and Henderson, so setting out the basic position. And he works his way through the authorities, all the way through to page 30 of the report and page 30 of the bundle, where we get to the parties have sidelined. If we actually start at the beginning of page 31, very top there, but Henderson and Henderson abuse of process, as now understood, although separate and distinct from cause of action estoppel and issue estoppel, has much in common with them. The underlying public interest is the same, that there should be finality in litigation and that a party should not be vexed, should not be twice vexed in the same manner. This public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation in the interests of the parties and the public as a whole. So the interest of finality is serving both a public interest and a private interest of the parties. A few lines further down, it starts, I would not accept that it is necessary before abuse may be found to identify any additional elements such as a collateral attack on a previous decision or some dishonesty, but where those elements are present, the later proceedings will be much more obviously abusive, and there will rarely be a finding of abuse unless the later proceeding involves what the court regards as unjust harassment of a party. It is wrong to hold that because the matter could have been raised in early proceedings, it should have been, so as to render the raising of it in later proceedings necessarily abusive. And this is the part we all know, that is to adopt too dogmatic an approach to what should, in my opinion, be a broad, merits-based judgment which takes account of the public and private interests involved and also takes account of all the facts of the case, focusing attention on the crucial question whether, in all the circumstances, a party is misusing or abusing the process of the court, seeking to raise before it an issue which has been raised before. Now, broads, merits-based, public and private interests. Now, in the same year, in the year 2000, the House of Lords also gave judgment in Arthur J.S. Hall and Simons, and we can pick up the relevant part of that in the judgment of Lord Justice Simon in Michael Wilson and Partners and Sinclair, which we have in tab 8, page 8. Page 8, this is the beginning of Lord Justice Simon's treatment of the law of abusive process. And on page 9, paragraph 41, he sets out a quotation from Lord Hoffman in Arthur J.S. Hall, describing the two policies which underlie discouragement of relitigation. The law discourages relitigation of the same issues except by means of an appeal. The Latin maxims often quoted are nemo debet bis vexari, pro una et eadem causa, and interest re publicae ut finis sit litium. They are usually mentioned in tandem, but it is important to notice that the policies they state are not quite the same. The first is concerned with the interests of the defendant. A person should not be troubled twice for the same reason. This policy has generated the rules which prevent relitigation when the parties are the same, autrefois acquis, res judicata, and issue estoppel. The second policy is wider. It is concerned with the interests of the state. There is a general public interest, interest re publicae, in the same thing not being litigated over again. The second policy can be used to justify the extension of the rules of issue estoppel to cases in which the parties are not the same, but the circumstances are such to bring the case within the spirit of the rules. And he goes on to refer to the example given by Lord Hoffman in that case of Reichel and McGrath. Then goes on to refer to Johnson and Gore Wood in paragraph 43, in Ray Norris 44, Sir Andrew Morritt in the Secretary of State for Trade and Industry in Bairstow case at 45, again picks up the private and public elements involved. And then at 48, on page 12, try to synthesise the principles, only the first of which I need for my purposes, 48, little 1, bottom of page 12. In cases where there is no res judicata or issue estoppel, the power to strike out a claim for abusive process is founded on two interests. The private interest of a party not to be vexed twice for the same reason, and the public interest of the state in not having issues repeatedly litigated. See Hunter, Hall, and Johnson and Gore Wood. These interests reflect unfairness to a party on the one hand, and the risk of the administration of public justice being brought into disrepute on the other. See again, Diplock and Lord Hunter's. Both or either interest may be engaged. And just for your Lordship's note, in tab 12 we have Tinkler and Ferguson, the Court of Appeal again in 2021, and paragraphs 30 to 31 and 35 of the judgment of Lord Justice Peter Jackson picks up exactly the same points. The twin purposes of both or either interest may be engaged. Now, why do I make and stress the point about the twin interests served by the doctrine of abusive process? Because Mr Azima is keen to stress, see most explicitly, paragraphs 31, 32 and 33 of his skeleton, that the primary concern of the abusive process doctrine is double vexation. As he puts it, the involvement of the same parties is the primary concern. Now, he makes that point because he thinks it's to his advantage, because the set-aside counterclaim, notwithstanding it is brought in proceedings against the additional defendants, and notwithstanding, as my learned friend Mr Macefield explained already this morning, that it is intimately bound up with the claims brought against the additional defendants, is inevitably, necessarily, a claim brought only against RAKIA. And he considers that this fact weakens the abusive process arguments. And not only does Mr Azima make this point, that the primary concern of abuse is double vexation, but it is one that found favour with the judge. The judge thought, and with respect wrongly thought, that it was a material factor against the success of the abusive process arguments in this case. And we see that if we pick up the judgment, which you have in the core bundle, tab 10, page 26 of the core bundle, paragraph 109 of the judgment. Paragraph 103 of the judgment, I'm sorry if I said 109. So the judge says, beginning of paragraph 103, while it is true to say that the court is itself concerned to protect its processes from abuse, and in particular the wasteful and disproportionate use of its resources, the finality principle is primarily focused on a party not being vexed endlessly by the same opponent on the same issues. Beginning of 104, he thinks he needs to take account of the fact that it is the additional defendants who are not parties to the proposed additional claim, but who are the ones opposing it. And paragraph 105, he considers it is the fact that the additional defendants who are opposing it, and the impact on them will be limited, is relevant to his assessment. Now, to that proposition the judge advances, I have two responses. First, it is wrong as a matter of law. There are two distinct reasons why the law discourages and sets its face against relitigation, and why the law encourages and pursues the aim of finality. One is the private interest of a party not to be vexed twice. The other is the public interest in finality. As that is clear, as Lord Justice Simon stated, from Hunter, Johnson and Gorwood, and Arthur Hall, as Lord Justice Simon put it, both or either interest may be engaged. And if both or either interest may be engaged, it is apparently sufficient if only one of them is engaged.
I mean, to say sufficient is not to say that the absence of the other is immaterial.
That I would accept. I would accept. It's not a either one, a binary situation.
But if that were right, then it isn't obvious that the judge was wrong to see it as a relevant consideration.
Well, insofar as he said the primary focus of abuse is double vexation, I would say that is wrong as a matter of law. Abuse has two focuses, neither the one or the other is primary.
Yeah.
If it said in this case the primary focus is, would that be wrong?
That would then not be a statement of law. It's a general statement as to what the position is law. So that may be wrong for different reasons, and may be incorrect in this case, but it wouldn't be wrong as a statement of law. So I say, insofar as he suggests one is primary, that is simply wrong. There's a second point that I make here, though. The point that Mr Azima makes is this. He says, you, Mr Gerrard, Dechert and Mr Buchannan, are not being vexed twice. So you don't get to complain about the fact that me bringing this claim is abusive. Now, I say that's wrong in law anyway, but let's consider it factually. The point being made is, you are not being vexed twice, RAKIA is. And RAKIA is not complaining about it.
Yeah.
But just pause there. RAKIA is being vexed twice. RAKIA is facing the same claim that it has already faced and seen off once. That, on its face, is abusive. It is contrary to the private interest of a party not to be vexed twice for the same reason, in Lord Justice Simon's phrase. Mr Azima's point is...
If RAKIA has dropped out of the picture, which it appears to have done, then isn't the question what position is vis-a-vis your clients?
To a large extent.
That falls within what Sir Andrew Morritt said in Bairstow, doesn't it?
Indeed it does. It does, but I would say this. Mr Azima's
It's
point is...
manifestly unfair to a party in later proceedings. The same issue should be re-litigated, or to permit such re-litigation would bring the administration of justice into disrepute. And I'm just trying to see where you say this case falls within those principles, if those principles are applicable.
Certainly. I say this. Deal with that straight off. It brings the administration of justice into disrepute because it offends the public interest in re-litigation of the same issue again. As for the private interest, I would say this. Mr Azima's point is, well, RAKIA's not complaining about the fact it's being vexed twice. And he likes to make that point for the forensic reason of saying, well, RAKIA's fled the jurisdiction, and I can take from that they think their case is hopeless, and so I like to make that forensic point. But does the fact that the party being vexed twice is not complaining about it, does that stop it being vexatious? And I would say, as a matter of principle, it doesn't.
I see the force of that. At the same time, it is a bit odd. You have an application to set aside a judgment obtained by RAKIA. RAKIA, looking at its letter, rather goes away with its tail between its legs. It's not going to take any part at all. And yet, if you're right, it isn't even open to Mr Azima to pursue a claim to set aside the judgment that RAKIA isn't trying to defend.
I say yes, analytically that's correct. I mean, if it's a question you put to my own friend Mr Maysfield, what had happened if Mr Azima had just commenced fresh proceedings against RAKIA? You, the additional defendants, wouldn't be there and therefore wouldn't be making the complaint you're making now. So in the real world, no one would be ventilating the argument to say this is abusive, but that is an argument that it is open to the court. Indeed, I would say it falls to the court to police its own processes. So in theory at least, the court should itself raise, well, hang on a second, this is the same action that has been, or the same claim, the same case that has been run before, and so should itself act to hold it to be abusive.
With the result that RAKIA, when this is over, can enforce its judgment, take its money, and say goodbye.
On the face of it, its judgment presently stands. So unless and until it is set aside, that is the case. And the sort of what is pregnant in that is, well, surely that's wrong. But to which the answer is, no, that is precisely the carefully calibrated judgment the Court of Appeal have drawn in this case. I mean, a slightly more pejorative way of characterising what the fate of the Court of Appeal's judgment and order in this case is a plague on all your houses. I have seen the evidence against Mr Azima. He backdated documents. He bribed people. I've seen all of that. He certainly shouldn't be left with the process of his fraud. I see the evidence that suggests and the argument that suggests RAKIA may have involved in hacking and concealing that from the court. That is obviously also to be denigrated if established. Where am I going to cut a line in this unattractive situation? I will leave RAKIA with its judgment. I will allow Mr Azima to pursue his claim for damages flowing from the hacking, and I will allow him to argue in favour of a different outcome on interest and costs. And that is, we say, the effect of what was ordered. And that, as I say, could be characterised as a plague on both your houses.
I mean, I understand that latter submission because that's focused on the effect of the Court of Appeal's judgment in this case, which is obviously critical. But I don't understand how it supports the submission you made a minute ago, which seemed to be that there was a general legal principle, the public interest part of Bairstow, which also separately supported the case. If it's just a manifestation of it, then fine, I get that. The way you were putting it a minute ago was that you had a separate point, irrespective of whatever the Court of Appeal had done in this case. There was a reason why this shouldn't be allowed. And that I don't understand.
I understand that question, my lord, and if that was the impression I gave, I apologise for that, because I also wouldn't understand that proposition.
What I take from this debate is that if we focus on what Sir Andrew Morris said in Bairstow, which is a pretty good starting point with respect, because it's been followed in many other cases. To permit such relitigation would bring the administration of justice into disrepute. On the facts of this case, what's said by the additional defendants is it would bring the administration of justice into disrepute if the case that's now presented falls within the prohibition, if I can put it that way, imposed by the Court of Appeal first time round. I mean, that's
exactly
the case, isn't it?
That's exactly it, my lord. That's why I say the
It's an
important part,
unusual case in the sense that
it is a most unusual case.
it's a case where the Court of Appeal, because obviously if the Court of Appeal had decided that on the basis that grounds 7 to 9 failed, therefore the judgment stood, and that was the end of it, that's all they decided, then the attempt to run the same point again with new evidence would fall foul of the Bairstow principle. It would be relitigation.
Indeed.
Pure
my
and
lord.
simple.
Indeed.
Yeah.
So, you know, when one drills down to it, and that's why we all agree that the ground covered by learned friend Mr Mayfield is the most important ground amongst the three of us.
Yeah.
Well, one wants to ascertain what it is the Court of Appeal decided, because one needs to understand what was argued before them. Are we relitigating that? And are we offending against that which they ruled by allowing it to proceed?
Yeah.
Now, my second heading was going to be fraud unravels all, the fraud principle. And the essential submission I wish to make under this heading is this, that whilst this principle, given the situations which it frequently arises, might often appear to be an all-defeating principle, an omnipotent force, it is in fact a principle that is subject to limits and limitations, and it is not, in the circumstances of this case, the trump card that Mr Azima would have it be or would wish that it is. And to address that, I need to address Takar and Koshi before making some points at the end. So, Takar, it's a case in which I'm sure the court is familiar already, and my Lord Justice Newey will be painfully familiar with the facts. But before getting into the case, let me identify the proposition that I would be getting into the case to establish. Mr Azima contends, see in particular paragraphs 34, 57 and 65 of his skeleton, that Takar establishes that a litigant is entitled to relitigate fraud even if they argued it before, if they have new evidence. That's the quotation from 57.1 of his skeleton. That, he says, is dispositive, and they say Takar is the leading relevant authority and that we are trying to duck it, and that Takar decides this case. Now, my proposition is that Takar does not establish any such proposition. There are conflicting obiter statements on a question to do with the situation that arises when fraud is alleged having been brought up in the first trial, but those are obiter statements in any event and still not directed to the specific question the court has to consider here. So Takar itself can be found in tab 10 of the authorities bundle, MAAB 10. As the court will be aware, the issue in Takar raised on a preliminary issue basis was whether or not a party who seeks to set aside a judgment on the basis that it was obtained by fraud had also to demonstrate that he could not have discovered the fraud by the exercise of reasonable diligence, that was the issue. My Lord Justice Newey said it did not. The Court of Appeal disagreed, and the Supreme Court overturned the Court of Appeal and held that a party who seeks to set aside a judgment on the basis that it was obtained by fraud did not have to demonstrate that it could not have discovered the fraud by the exercise of reasonable diligence. And that alone, is what the case establishes. This was not a case in which the relevant allegation of fraud, i.e. the forgery of the signature on the profit share agreement, had been raised at trial. It was an entirely new point, not raised before. As such, TACAR is not a case addressing itself to or grappling with what the position is when the issue of fraud has been addressed before, and it's not addressing that issue even in connection with the reasonable diligence question, let alone in terms of the whether that would amount to an abuse question. And Lord Reid is at pains to make that clear in his judgment. His speech begins at page 15 of the authority. And one notes that Lords Hodge, Lloyd-Jones and Kitchen agree with him. He works through the Court of Appeal judgment and the authorities, frequently making the point that this is a case in which fraud allegation has not been raised before. So, for example, in paragraph 20, page 18, handle, at letter H, considering Henderson and Henderson, points out it does not speak on two subjects which are critical in the present case. The first of these is whether the rule applies where the point was not in issue during the
Sorry, which paragraph you on?
I'm sorry, paragraph 20, letter H. And he's observing why Henderson doesn't help on what is relevant. In his case being a case in which the fraud was not in issue between the parties in the first trial. And that's obviously very much the point. His case, that case was one in which the fraud was not an issue on the first trial. The same point comes up in paragraph 32, 21, 470 of the report. In the first instance, it says, beginning of paragraph 32, this is not a case of commencing new proceedings where the same issues arise. As Patten LJ earlier said, the question of Mrs. Tackar's signature having been forged had not been raised or decided in the trial before Judge Pearl. The claimant does not seek to set aside Judge Pearl's decision on any of the issues decided by him. He makes the same point again on the next page of paragraph 35 when he's discussing the phosphate sewage case. In paragraph 40, on page 23, he's then discussing the Privy Council decision in the Etoile case. Distinguishing the Etoile case, which was a case, for what it's worth, in which the Privy Council was content for the Court of Appeal of St Vincent's to have struck out a claim on the basis that it alleged a fraud that had already been alleged before and determined by another court. So, repeatedly making the point, this is not a case, one he's dealing with, in which the fraud has been raised before. And one can skip to his conclusion in paragraph 54, page 27. And this is the ratio in paragraph 54. He concludes that Etoile and Bracco are not authority for the proposition alleged. If they are authority for it, that should not be followed. And his final sentence, in my view, it ought now to be recognised that where it can be shown that a judgment has been obtained by fraud, and where no allegation of fraud has been raised at the trial which led to that judgment, a requirement of reasonable diligence should not be imposed on the party seeking to set aside the judgment. That is what the case decides. But paragraph 55, it goes on, and this is what's had focus in this case. First, let's read it. Two qualifications to that general conclusion should be made. Where fraud has been raised at the original trial, and new evidence as to the existence of the fraud is prayed in aid to advance a case for setting aside the judgment, it seems to me that it can be argued that the court having to deal with that application should have a discretion as to whether to entertain the application. Since the question does not arise in the present appeal, I do not express any final view on it. The second relates to the possibility that, in some circumstances, a deliberate decision may have been taken not to investigate the possibility of fraud in advance of the first trial, even if that had been suspected. If that could be established, again, I believe that a discretion whether to allow an application to set aside the judgment would be appropriate. But once more, I express no final view on the question. So, the 2 points to make out of that paragraph. One, he is expressly not deciding what the position is if fraud in question has been raised at the original trial. And two, in both his qualification situations, he considers that a discretion would exist as to whether to entertain the application. A discretion to entertain rather than a discretion to refuse to entertain, which rather suggests that he considers the default answer in such situations would be no, or at least distinctly doubtful. But he's not deciding the point. Lord Sumption starts over the page 28, and one notes there at letter E that his speech is also agreed in by Lords Hodge, Lloyd Jones and Kitchen. And he says at paragraph 59, subject to what follows, I agree with the judgment of Lord Carr. I don't think it's necessary for present purposes to review his judgment in detail. For present purposes, the relevant points in paragraphs 66 and 67, page 31. And 66, I would leave open the question whether the position as I have summarised it is any different whether fraud was raised in the earlier proceedings, but unsuccessfully. My provisional view is that the position is the same for the same reasons. If decisive new evidence is deployed to establish the fraud, an action to set aside the judgment will lie irrespective of whether it could reasonably have been deployed on the earlier occasion, unless a deliberate decision was then taken not to investigate or rely on the material. And he goes on, I recognise the risk of frivolous or extravagant litigation to set aside judgments on the ground of fraud, but like other members of the court, I think that the stringent conditions set out by Akins, Lord Justice Akins, in the Royal Bank of Scotland and Highland Partners, combined with professional duties of counsel, are enough to keep it within acceptable limits. I do not think that the imposition of further conditions would be consistent with the long-standing policy of equity of reversing transactions procured by fraud. So, he expresses a provisional view. You can reopen if decisive new evidence, though query what decisive means. Even then, he's only saying one would not be barred by failure to exercise reasonable diligence. He's not saying anything about whether you would be barred if your claim was abusive because you were relitigating the same point of fraud.
Is he not impliedly saying that? Is he not saying, well, if you've got decisive new evidence, it doesn't matter whether reasonable diligence comes into it or not. Therefore, if there is decisive new evidence, his provisional view is you can reopen.
But that, I say, it's not a necessary conclusion that that's what he's saying. He's not considering at all what would be the situation if your answer to it was, this is abusive. Now, I take it that it might come to the same, if he did answer that question, given this indication, he's likely to answer it in that same way, and that would get back to the debate you've had with my learned friend Mr Masefield, has there been a significant change of circumstances here, such that it's not abusive to reopen this point again?
Well, yeah, then that's the critical issue. We come back to the same point, don't we? As to whether what Mr Azima is seeking to do here falls foul of the Court of Appeal judgment or not.
Indeed, Mark. Indeed, Mark. But I would say this, I mean, Lord Sumption is expressly not deciding the point, and Lords Hodge, Reed, Lloyd Jones and Kitchen have agreed with both him and Lord Reed. He has said something different to Lord Reed. Lord Kerr.
Yeah.
And they can't, those three justices can't have agreed with both of them if they thought that these statements were anything other than overturned.
Can I just pursue it a moment longer?
Yes.
On one view, Lord Sumption is saying, don't worry about discretion. If you've got decisive new evidence, you can reopen. The other judgment says, I mean, both say they're not deciding, but the other judgment says there's a discretion whether or not to entertain. Do you say as your submissions that either of those tests is right, or that they're both wrong, or what?
Well, I say neither of those is binding on this court.
No.
Neither of those is a statement of the ratio of the case. As to what, in truth, the correct analysis should be, I say the court will find it in Cauchy, that we will come to shortly, which is where the allegation of fraud has been aired once before. The court engages on the broad merits-based abuse of process analysis, but factoring into that, a very important factor in that, and it is an important factor in Lady Justice Arden's judgment, is the very fact that it's a second bite of the cherry.
But that isn't obviously supported by either of the majority judgments in Tack and Grace.
No, Lord Carr's judgment says if you are revisiting an allegation of fraud, there is a discretion on the court as to whether to entertain that or not. Now, it doesn't sketch out how that discretion should be exercised or what exercise the court would be undertaking, but I would respectfully submit that within that, part of that analysis of should I entertain this or not, will be a question of we are revisiting a question of fraud that has already been investigated. Is that an abuse or not?
And just pursuing it a moment longer, of course, I'm not quite sure that it comes to anything very much, but the abuse authorities say it's not a question of discretion.
No,
There's a right answer.
I
I'm
agree.
not sure that helps the judge much in any particular case, but there is a right answer.
I agree.
Whereas Lord Carr is saying, no, it's a discretion.
And there's also another complication, which is that the abuse authorities say that it's a relevant consideration that you could have raised the point in the first set of proceedings if only you, as it were, done your job properly. And yet, at least Lord Sumption seems to be saying, well, whether or not you could have, through the exercise of due diligence, realised there was a point available, is not relevant. So one does have at least potentially kind of.
One does. One has some clashing thoughts on the subject, perhaps unhelpfully for this court. The first answer is none of the statements in TACAR decide this for you, because they are not directed to the very question you have to consider, and one has some obiter statements. But insofar as, and TACAR is considering this case through the prism of reasonable diligence, it is not directing itself to the question of abuse. And I appreciate, my lord, that actually when one looks through that different prism, one ends up asking oneself a number of the same questions. But it is the case that the abuse authorities tell one that it is a broad merits-based multifactorial assessment. And so when considering it through that prism, it must still be that.
What's striking is, picking up on the point I was just putting to you, really, Lord Briggs, in paragraph 68, addresses precisely this point. He actually says in terms.
Indeed, he does, my lord.
That in effect, what he says is that lack of diligence in pursuing a case of fraud during the first proceedings ought to render a particular claim to set aside the judgment in those proceedings fraud and abuse of process.
He does, and I was just going to come on. We've looked at the two leading judgments. Lord Briggs's judgment is undoubtedly a minority judgment insofar as it's not the judgment or speech in which the majority agrees, but it is a helpful analysis in my respectful submission.
Well, if this is all obiter, then it's just an expression of an obiter point of view, which may, as it transpires, be correct.
It certainly is obiter. I think the question that the court is testing with me is, despite the fact it's obiter, does it turn out to be correct?
If trying to sort of trying to stand back from it and without the benefit of the views of their lordships, as it were, I think would be saying if the issue of fraud has been previously litigated, So it's, as it were, it's on the table.
Yep.
And then subsequent proceedings, the unsuccessful claimant seeks to raise, or the unsuccessful party seeks to raise the issue again, but with further evidence. Most authorities would, most of the authorities on abuse at least would say that it must be relevant whether or not the unsuccessful party could, with the exercise of due diligence, have found that material first time round.
I accept
And
that.
merely because it's a fraud case shouldn't in itself excuse you from that. Now, of course, there's a you know, in fraud cases, there's also the consideration that the mere fact you may have been careless doesn't mean you can't rely on fraud.
Absolutely.
But there must be some relevance to how you conducted the first set of proceedings.
I don't dissent from that, Rod. I mean, there must be a factor in there in the abuse analysis, and the abuse authorities tell you that. If I may just briefly go back to where we started this whole debate looking at TACAR, it was to establish the fact that the answer to the question your lordships have in front of you is not given to you by TACAR.
No.
And that is a proposition set out in my learned friend Skeleton, that it is answered for you by TACAR, and I say it is not.
I mean, on any view, we're dealing with things that are overturned. In terms of the significance of Lord Briggs' judgment, you do find in Lord Sumption's judgment, with which Lord Hodge, Lord Jones and Lord Kitchen all agree, express disavowal of the Briggs' views, both in paragraph 63 and in paragraph 64.
That is, I entirely acknowledge that. For me, it is a view that the majority have not adopted.
No. Indeed rejected.
But what is, I think, helpful from Lord Briggs is his paragraphs 83 and 84 on page 36, in which he is just considering the engagement of the finality principle, even in cases where one is seeking to set aside for fraud, and making the point that applications to set aside for fraud engage the finality principle, because at the heart of seeking to set aside for fraud is relitigation. The very heart of trying to set aside for fraud is not only does one have to litigate, one's had the first trial, one has a second trial as to whether one should set aside for fraud, and then potentially a third trial to decide the same point, such that, and this is not a point objected to which the other justices object, and I would submit is right, that in these cases the finality principle is always engaged. And I would adopt that from him.
Is that a convenient moment to break, Mr.?
That is indeed one.
Very well. We're doing pretty well, aren't we?
We're doing, certainly as far as I'm concerned, we're doing well. I won't take much longer tomorrow morning, and then another from Mr. White.
We've also got Cushy to deal with.
Indeed, that's really what I have to deal with, is coaching.
So 10:30 tomorrow.
All rise.